Okay, so hello everyone, and welcome back to a special episode of Pulso Legal. That is the podcast from Arias, on which we open a space for our partners and our friends to be able to share experiences and different subjects of interest. This is a very special episode because we're doing it because of Compliance Week. That is a yearly event that we have in Arias. That this is the fourth time that we have it, the 4 year in a row that we have it, and it's a week dedicated to compliance and different matters related to this important area of expertise. And this year we are focusing on the relationship between AI and compliance, specifically in artificial intelligence and compliance, driving efficiency and managing risks. That is like the main topic that we're going to be talking about all throughout the week. And specifically in this very special episode, we are talking about AI risk and compliance and strategies. With us today, we're very happy to have Anna Petrovic, that is the Director of Financial Services and Compliance and Regulation Practice at Kroll. Anna is based in Los Angeles, and she has over a decade of diverse experience, including her time as U.S. Security and Exchange Commission, and has done extensive work advising clients on financial and regulatory matters. So, Anna, thank you so much for being with us and taking the time.
Absolutely. I am delighted to be a part of this conversation. It's an area that's near and dear to my heart.
Thank you. Just a quick intro to you. How long have you been working at Kroll?
Sure. So I joined Kroll about a year and a half ago.
Mm-hmm.
And before that, I was at the SEC for 10 years
Mm-hmm.
and had a lot of life changes, including a move across the country, which was a fantastic career opportunity to bring that SEC experience to the regulatory consulting world.
Great, great. And it should have been a big change going from the SEC to the private sector. And
Absolutely, absolutely. SEC, obviously, I was in the Division of Enforcement. So certainly very regulator mindset, really out there to protect the public. And then now shifting into the private sector, I have an entirely new level of appreciation for the practical challenges to get it right before the SEC, right? Because often when I was in the government, you see the really bad actors, the folks who are really disregarding the rules. But when you come into the private sector, you see so many people want to get it right, but there could just be a lot of resource challenges or other ambiguities that really make it difficult to comply.
yeah, yeah, I understand, and that's something that we deal with it in every country. So
Yes.
so going into the specifics of the matter today, in AI and compliance, we first reach out. We have a very good relationship with Kroll and working relationship back and forward. You're a very interesting article that you participated in that was very interesting for us and for me in particular. When we were discussing about going into AI and as the subject for compliance, I immediately thought of you because of this. So, when you talk about it, in AI and risk and directed to financial sector, but in general, as use of firms adopting AI, as a general matter. eh, how integrated is AI becoming into the practice day to day of firms and law firms and law practices in general in your experience?
Sure. I think that it is dramatically taking off. And I think there's a huge debate over what constitutes AI. Because if we look back, in many ways, we've been using AI for many years,
Hmm.
right? So in the SEC registered space, many firms use robo advisors to do automated trading recommendations. And then on the flip side, from the operational standpoint, you look at even programs like Microsoft Word, right, that now have a co-pilot feature which can do transcripts for you. And so we have tools that were not intentionally perceived to be AI, but now have AI functionality. And certainly with the proliferation in recent years, there's almost a race, right? A competitive race to adopt these tools to get an advantage, so to speak.
Yeah, and when you go directly into, for example, financial sectors and financial services, what are some of the uses that AI has been or that they have been given to AI in financial services?
Absolutely. So firms have been really testing out a variety of tools. On the portfolio management side, firms are using it to do due diligence, right? How do you get a larger data set and come to a conclusion faster on what could be a worthwhile investment to recommend? And then similarly, a lot of firms are using data and predictions to assess what types of investments their clients are more likely to accept or be interested in. And so they're tailoring those recommendations on a somewhat automated basis. So that's just a few examples on the portfolio management side. On the compliance side, so in my world, there can also be benefits, right? Firms can use it to detect misconduct, right? Right now, there's this very sort of laborious process to do email reviews, right? To detect a wide range of violations. It's not necessarily the most efficient. With AI, they may be able to use additional tools to detect misconduct earlier, such that compliance can get in there and remediate sooner.
Yeah, and in that sense, when you said, well, email revisions, for example, and when you use the tool to enter information about, upload the database or upload specific documents that you want to use a search on and categorize information and so forth. That's something that I understand is being done a lot. So are the risks that the companies should be able to consider or should consider when using this? Because and just to give you an example, something as easy as a corporate, as a firm, or as an attorney in a firm that wants to use ChatGPT, for example. So it introduces, several parameters to ask a question or to ask for a document to be drafted, and you include the name of your client and information about a specific case and so forth. And that's something that the algorithm undertakes as part of learning. So you're actually are you feeding confidential information to a system, for example? So what kind of risk are we talking about here?
Absolutely. I mean, you really got to one of the greatest risks that we identified in the article itself, right? Because if you have these tools, you don't know how they're otherwise sharing that data set that you've been inputting to help you generate your own models, so to speak. And so you certainly have to consider in the US, not just SEC regulations, but data privacy, intellectual property. It can really, it's limitless, so to speak, there. I think, in terms of the other risks, the one that I really think is the most concerning in my world is just the limitations on accuracy today and the gap in what people think AI can really do, right? Because AI is, in theory, a tool that you can use to augment your practice, but you cannot completely delegate or rely entirely upon from an accuracy standpoint. Because it's only as good as the data set, and that data set is constantly evolving. And so if you're relying on AI entirely from the tool itself and not implementing other controls and policies and testing, you could be giving investment recommendations, performing investment due diligence, or sending communications which are not accurate. And that can rise to a breach of fiduciary duty, right? And arguably harm your clients, which is not what firms want to do. So you really have to be thoughtful in not only testing what tools you adopt, but understanding how to deploy those tools if you choose to adopt them.
That goes a little bit about, and making like a little segue, just to come back quickly.
Sure.
One of the main questions is, I saw one lecture which began with the questions: Are attorneys going to be extinct at some point? That's a big concern here, and right now the answer, I think, is not, because there's always going to be a human revision of anything. Everything that you do with these kind of things. I remember, for example, when preparing for a trial, I feed several documents into a tool and said, prepare a questionnaire here for witnesses, depositions and so forth. You have to double check
Yes.
at any time. So how do you prepare people for this in your firm? How do you prepare the firm exactly? I don't know how to use this and how to keep the human element participating here.
Right, right. No, absolutely. And I think that, at the same time, we encourage people to explore these tools, right?
Hmm.
Because that process you just described of feeding in data and preparing questions probably still saved you time,
Hmm.
right?
Oh
In
yeah, of
terms
course.
of, yeah, pulling it together. So you don't want to shy away from these tools altogether. But certainly from a testing component, you should be bringing your own independent knowledge and training and independent research to test the accuracy and the reliability of the tool itself.
Hmm.
And so, we certainly recommend that our clients do testing before onboarding, ask a great deal of questions, right? It's not just what the output of the tool can provide, but
Hmm.
how is the tool ingesting data? Is it
Hmm.
using proprietary models where there's robust contracts in place that say, yes, you can use this information and then share it with firms? Or is it scraping from the web and taking data that may be less reliable or compromised? So you really have to do that deep dive due diligence. And then if you do decide to onboard the model, really understand how to deploy it and then test, test, and test. It is going to be a moving target with AI, particularly as these models and tools are constantly evolving at this day and age. And if you don't continuously test, you will run into significant errors.
And how do you do it, for example, in application in a firm? Do you have like an internal policy guideline? Are you training people on how to use this? Does it come from the top, or is there like a compliance officer? Is the work of a compliance officer? Who should be in charge of this, and how?
It is such a fantastic question. It has to be a team effort, right? You can think of the compliance officer as the center of that team or the
Hmm.
leader of that team, but they have responsibilities. The officers and directors have legal and regulatory obligations as supervisors of firms to actually comply with the regulations. And then same with individuals, they have their independent fiduciary obligations. So you don't have to persuade personnel that they need to pay attention because it could affect them both
Hmm.
individually and the firm wide. But certainly the first step we recommend is doing a robust mapping exercise.
Hmm.
You have to understand where are the blind spots in your firm, right? Because it's very easy when you're deciding whether to onboard a new tool, but you may have existing tools that you had approved on your platform that now have AI technologies, which
Hmm.
invite risks. So you need to go back and do a full inventory. And that's going to be talking to your operational personnel, your finance personnel, talking to personnel in different departments to understand what tools they're using, and then doing that additional assessment of, is AI involved? So that's the first part from an internal. The second layer is your vendors, right? Because
Hmm.
you just mentioned law firms, right? Your firm, you use this program to generate questions, right? At Kroll, we've used programs to help us in our day-to-day. Your vendors also may be inviting AI risks that you may be blind to, right?
Hmm.
Those vendors may in turn have their own outsourced vendors, which have their additional. So there's multiple layers, right? Multiple layers of risk. So you have to do that due diligence and maintain oversight from a vendor external facing component.
And how do you do that with vendors? For example, do you give them guidelines on what they can use your information, how they can use it, how can they apply it to AI tools?
Absolutely. Absolutely. It's a great question. So a robust questionnaire and an on-site visit and dialogue should be key, particularly if you know AI is a significant component of that vendor's program. And those questions should be really from a compliance perspective broadly, right? Not just do you use AI, but do you actually pay attention to data security and data privacy laws, right? Have you vetted that you are allowed to use this data and share this with us? And if so, can you provide us assurances that you do have the legal entitlement to the data? And then this is one is really, really important. We know breaches and incidents happen every day. Does that vendor have a breach and incident response plan? And will, make sure you negotiate that response plan includes notifying you, right? In the event of a breach, even if it may be earlier, so you can assess the risk. So keep in mind, they're incentivized to work with you, right? They want your business. So, negotiate the terms. And then a lot of these risks, the firms are aligned, right? The vendor should be thinking about the same issues. And so it's really in everyone's interest to have this really thoughtful conversation up front. But then here's the key, it never stops, right? You have to have periodic due diligence, check-ins, site visits, updates, because of this evolving use of the technology.
And I will think that, as to any kind of compliance matters or regulatory requirements or procedures, and any compliance system is a live entity, right? It's a live entity that you need to be updating, like you said, and part of this is continuously training people into understanding how important this is.
Absolutely. So the policies and procedures and the training go hand in hand. And if you pay attention to the SEC's messaging, and I can tell you as a former regulator, you cannot use cookie cutter boilerplate policies and procedures. In fact, those may actually get you into more trouble than if you had nothing at all. You have to have policies that are really tailored to your firm's risks and how you're using them. And then for the training, really think about it as setting up your personnel for success, right? Because this is a complex new area. Personnel are inundated with training on all fronts. You really have to be creative, right? So at Kroll, we really recommend that our clients use real life examples. So we'll take fact patterns from SEC enforcement cases and then put them into hypotheticals and quiz personnel. How would you handle this situation? Or what is the risk here? What is the firm's policy in this situation? What is your obligation? Rather than you have a fiduciary obligation, right? Like that sort of level of creativity is more likely to generate more effective training.
Yeah, and how much do you need involvement of from the management positions in the firm, or how involved must be everyone here, or is it something like an individual effort from the compliance department, the legal department, or does it require? I'm saying the same thing all over again. How involved should people be?
Right. So I would say it's the phrase that the public really doesn't like to hear from lawyers of it depends, but it really depends on your own program and the risks. But certainly the training should not be a broad training for all personnel. You should tailor it to the personnel's roles and responsibilities, right? So if you have portfolio managers that are using AI tools to do investment due diligence and investment recommendations, that training is going to look very different from the compliance personnel who are doing vendor due diligence, right? Approvals. And so the more tailored you can provide the training, depending on where the risks are, the better your program is set to mitigate or eliminate these risks altogether.
And I believe it could be important, for example, to have like a, I don't know if it's a hotline or a contact or a key contact person, just to be able to ask questions if you are uncertain, because at some point, all tools, I remember we use an app for reading PDFs, and all of a sudden it had an AI tool, and
Right.
so there's always this intrigue to enter into see how does it work, and should people ask first or before using a tool, or what? How do you ensure that? Because you don't want to cut away from creativity, as you said before. So how do you balance that?
Right, right. So it does start from a tone from the top when it comes to a
Hmm.
compliance culture.
Hmm.
So at Kroll, we do a lot of mock SEC examinations and testing, and we will interview personnel and ask them, who is your chief compliance officer? Or
Hmm.
name three people in your compliance department. I would say at least one time out of five, personnel don't know who they are. That's not great, especially when the CCO is in the same interview, right? And they're sitting there like, right? So you have to have a level of bridging that communication, especially now in this world where we're working virtually more and going less into the office. You
Hmm.
have to have touch points with personnel so that they feel like they can come to compliance with questions. And same with the supervisors as well. They need to have that same sort of touch points with their direct reports so that they feel comfortable and in fact encouraged to come to them with questions. And that situation with the tool evolving, as you mentioned,
Hmm.
had a client go through something like this, where a tool was approved for one purpose, and then over the course of years, it had all these different features, which compliance was blind to because they didn't know the tool evolved. So you need to have, as part of your policies and procedures, touch points with not just personnel using the tools, but your IT and data security personnel as well, to understand how have these tools evolved. Are there new risks we should be thinking about? Maybe
Hmm.
even a notification from the IT team. Please notify compliance if there's been an update, which now adds an AI component to this tool.
Hmm.
We need to be looped in.
And that, I believe that's so important, because you mentioned over the years. Sometimes it's over the weeks, over the months, because apps are constantly evolving and adding new features, and and it and it sometimes they evolve so fast, like for example with messaging applications, for example the WhatsApp, everyone has a chat group, right?
Yes.
And how do you manage privacy here? How do you manage the privacy of the information of your clients from in this increasing speed on which apps develop?
Absolutely. I think that you're raising one of the practical challenges that I was mentioning at the outset of the call of it's really easy to say, have this program in place to mitigate all these risks, but in this world that's moving at lightning speed, in some ways it's impossible to get it right
Hmm.
perfectly, right?
Hmm.
So I think the first step is recognizing you have to have a program that's reasonably designed, not perfect, right?
Hmm.
Reasonably designed. And so the more you can institute controls and testing, the more likely compliance is going to become aware of updates which truly invite new risks that require additional controls,
Hmm.
whether that's notifications to compliance on the updates, regular meetings with security professionals at the firm, getting routine email updates or newsletters from organizations on the, evolvement of technologies. All of those tools can be used to make sure the program is reasonable, but it will never be perfect, unfortunately.
Hmm. And going forward into the future, do you predict, or do you prediction is a little tricky to say, but do you believe that there's going to increase, there's going to be an increase on the scrutiny on firms and in companies regarding how they manage AI?
Yes, yes, and yes. So I think that the industry has had a really, really nice cushy window for a
Hmm.
bit, right? So in the US, in particular with the SEC regulations, they announced these proposed rules. They put a pause on the rules, but you're kind of seeing what risk areas they deem important that need to be addressed. But in the first few years, what we're seeing from the SEC are a lot of cases involving AI washing. So firms that are exaggerating how great, their AI gives them competitive advantage, right? And they want to try to bring in new clients with these fancy tools, but the tools aren't actually being used or
Hmm.
they don't actually perform that way. In some instances, it's even more innocent in that firms actually do adopt the tools, advertise that they have the tools, but then they don't know how to use them and deploy
Hmm.
them. So they're not actually taking advantage of the tool, even though they paid for it and marketed for it. So those are like the low-hanging fruit type
Hmm.
cases that from my SEC regulator world it's the least controversial, right?
Hmm.
Because it's easy. Do what you say what you do, right? Very, very easy. But the next wave, I think, is going to be more complex of conflicts of interest, data privacy, disclosures. I think it can get much more nuanced in coming years.
And yeah, I definitely believe that you're right. And not only on scrutiny, but also in internal organization in the firms and in the companies. Is it, do you believe or do you foresee any changes or any way in which operational strategies, in corporate governance, is this going to have an effect on that at some point?
I absolutely do. I absolutely do. I think that everyone's recognizing that to remain competitive, in many ways, you have to adopt these tools, right?
Hmm.
Because your peer firms are going to be doing it. They're going to get faster or better than you unless you keep up with them. So
Hmm.
I do think we're going to see it not just from the business model standpoint, but the operational side, the use of these tools. And it can be kind of exciting too. It doesn't have to be all fear, right? As long as you
Hmm.
have controls in place, you can use these tools.
Yeah, I, you're absolutely right, and there's a lot of things need to that are going to change and that you need to be updated. And just to give you an example, for example, here in Latin America, specifically in Costa Rica,
Mhm.
we work with a lot of U.S. clients, or or uh, European clients and so forth. And sometimes they ask you for a translation of a document, and you used to need to have a very good paralegal with a very good English just to have him translate a 50 pages lawsuit. And now you just upload it into an AI translator, and you have it in like 2 minutes or less, and you have a translation. So there are, in this example, for example, there are a few things that rise up from the conversation that we have. Is there are you securing the privacy of the information because what you're uploading is information about an ongoing legal case? Are you 100% sure that you are that the translation is correct? Because, for example, there's one I once translated a lawsuit, and it says in the evidence in the evidence section, in Spanish the word is prueba, right?
Okay.
But prueba is a word that can mean evidence or test, for example,
Oh,
an exam. So
oh,
the translator translated to test
right.
the chapter. So it wasn't a test. It was not an exam. It was the evidentiary section of the lawsuit. But the translator understood that. So even though it's an AI translator, it wasn't able to understand that it was talking about a lawsuit and that the word had two meanings. So you still need to oversee and to double check everything at some point.
Absolutely, right? Like that probably saved everyone time and resources overall, right? Because I remember those days having to hire a translator, a paralegal, transcribe, proofread, not to mention how long that takes. And then now you can do it in a matter of seconds or minutes, right? So you've saved that time, but the human component is the quality control check, right? You do have to have that review, and it's kind of comforting, right? Because back to your first observation, right? Like it's, not every single position will be eliminated because of AI. It's just the tools will change, right? And being able to use it effectively. So we've seen similar, you can use it to scan SEC filings, to look at earnings call reports and have those transcripts consolidated and extracted for certain information. So there's so many great uses, but it's not 100% accurate.
No. And now that you mentioned this in efficiency and time proof, I was looking at a lecture again, and they brought up a subject that it was very interesting regarding how to charge this, for example, and how does implement your fee structure. Because in firms that work with billable hours, how do you bill something that you used to take 5 hours and now it takes 5 seconds? And
Yes. Yes.
so yeah, how are we going to handle that? It's a matter of and not only in firms, in companies itself. How do we manage that? I,
Absolutely, right? And the clients too, right? Because I think all of us face resource challenges, certainly face it in government. We face it now at Kroll. Our clients certainly do, right? And so clients, in some ways, may be more empowered to make more decisions of where they want their resources to go, right? So that situation you're describing with the translation, maybe the client said it's worth it for me to pay a fixed fee for you to run one search or a subscription than to pay $1,000 rate. I don't know what the going rate is for you or in your geographic area, but it's probably less to pay a fixed fee, right? Search. And then maybe, that can be an opportunity for there to be more legal analysis, negotiation, enhancing policies and procedures. So it's certainly going to shift how business is performed, right? And how profits are made. And I think it will give individuals more options, right? I think about the days where you had to go to the library or get an encyclopedia, right? To do research, right?
Yeah.
And you go and you pull the cards from the library system, and then you wait for the librarian to bring it. And then now we have internet, and you can search and find almost everything at your fingertips. It almost seems bizarre to go back in time. That's probably what AI is going to be for us in so many ways, and how we conduct business going forward. It will maximize efficiency, but we'll all need to develop skill sets on how to use it properly.
Yeah. Now that you mentioned that, I used to, I was going to say 20 years ago, but actually like 3 years ago, I still went, we went to trials. I do a lot of, for example, criminal litigation. So we went to trials carrying, I don't know, 20 books of the case file. The case file divided into 20 folders, like this, a big each one, with 20 books each one of the paralegals. So you used to use the card, just with the willing card to brought everything to trial. And now you only get your iPad, your iPad or your laptop. You have everything there.
Right, right. And yeah, then you think about data storage and right, and then the loss of it, right? It's almost more secure in some ways because you have it archived. And but yeah, it's our lives have definitely improved with technology. We have to remember that I think particularly with AI, there's just so much fear, right, about what can go wrong. But when we think about how individuals used to be nervous about using an ATM for a bank, right? This is just the direction we're going in, and hopefully it will make massive improvements for all parties involved.
And Anna, just to be wrapping up, but if I ask you, what will be the main recommendations that you will give someone, that is, or a company or a firm that is thinking about this and thinking from the perspective of I want to use this, but I want to be careful. And so, I won't give you a number, but, whatever the amount of recommendations that you believe, this is like the top things that you need to be on the lookout for.
Sure. I would say map. So identify where your risk exposure is, tailor. So prepare policies and procedures and controls that are tailored to those risks, test, front end and ongoing, and then disclosure is your friend. So you need to disclose, particularly in the SEC registered space, how you're using this technology, what the risks are, and really making sure those disclosures are constantly being reevaluated depending on how the tools are being used or if there's an incident that occurs. Those are the kind of fundamental, I would say, pillars of a strong compliance program.
Now that you say disclosure, for example, should we inform our clients of the tools and what we're using them for and where we're storing their information? Should they know and consent to this, or?
So in the SEC space, disclosure is typically your friend, but to the point where it doesn't invite more risk for your clients, right? So they certainly need to understand how there is AI risk exposure and what the firm is doing to mitigate those risks and to understand potential collateral risks. I mean, another really interesting example that I don't think a lot of folks are thinking about is also, if you decide not to use AI, in many ways that invites a risk disclosure because you should be telling your clients, we may be competitively disadvantaged because we're not using AI. And so in the SEC world, it's definitely something that you need to consider. And then the incident, if there is a data privacy issue, if there is a PII issue, you may need to update those disclosures or inform particular clients depending on what the issue is and what you're doing to address it.
Okay, no, I completely agree. And there are individual regulations that you should consider regarding disclosures. For example, in Costa Rica, there's regulations for data breaches and data privacy that you need to disclose to a specific authority. But and that goes to the tailoring part that you mentioned, because sometimes you will need to tailor regarding a specific jurisdiction or specific areas or depending on several specifics. But there should be like a general mapping or a general construction of how this should work, and then you go about tailoring in each section, right?
Absolutely. And the way I think about it with the building blocks of a compliance program is that whenever there's a development, there should be a policy or a practice that compliance and legal are deciding whether this warrants new or different disclosures. Because that's really key, right? Where sometimes firms start out with great controls and then something happens, the IT service provider goes bankrupt, right? Or there's a hurricane, right? And something, right? There's some sort of disastrous event. There's a pandemic or something that could affect it. You need to then update your disclosures and have that built into your compliance program as part of your regular assessment. Where firms get into a lot of trouble is they wait in the US for their annual filing requirements. And that's not the obligation. The obligation is to update any material developments.
But yeah, as you mentioned, disclosure is your friend, but I think that it goes a little bit beyond transparency, right? That's more of a, one of the main elements regarding compliance that we try to inform or try to transmit to people and to the different actors that we interact with, is that you should construct compliance as part of your DNA, as part of your corporate culture, and it goes a long way into transparency. It should be an automatic thing regarding how do you operate.
Absolutely, absolutely. It's going to be better for business, right? And that's what the non-compliance professionals have to keep in mind, right? Because where we've seen in the US where there's SEC enforcement actions, from what I can tell from the settled orders, they're racing to get these technologies and they don't have the compliance framework in place. So all of the good that they're trying to achieve, all the competitive disadvantage gets completely undercut by this enforcement action. Now they have penalties, they have to pay back clients, they have reputational damage, right? So having a robust compliance program in place will protect you. And I think the other aspect of just keeping in mind the why, not only that it's the right thing to do. I mean, I'm a compliance nerd, so I'm all about compliance. But if you have to be persuaded, there's individual liability on the line. You know this as an attorney, right? Your CEO, CFO, even individuals making investment recommendations. It's not just the firm's reputation. You can be charged by a government regulator. So it's in your interest to also be part of a firm that protects you, that has a strong compliance program in place.
Sure. Sure. At the end, it becomes a matter of personal engagement, but at the end, it's a matter of corporate engagement and having everyone involved in this, in believing in it. And it's a difficult task, but I think that is becoming more and more clear to people.
Absolutely, absolutely. In the US and the SEC investment advisor space, the only position that the firm's required to have is a chief compliance officer.
Oh, really?
Right? Yes. And so now you're seeing firms, it's only as good as the executives treat it, right? So that CCO needs to have a seat at the C-suite table, right? They need to be part of those discussions because they're going to have insights into how business decisions may implicate compliance risks. And if you're not having that dialogue and invitation, it could be really disastrous. And on the flip side, I also counsel a lot of CCOs to not start with no, right? You know this as a lawyer as well, right? Because clients really don't like to hear the no, you can't do that. And so I counsel them to say, yes, when you do this. Yes, if you do this. Yes, after you take these steps. So that they understand you're trying to help them reach the business goals, the broader corporate mission, but protecting them at the same time.
That's actually a great advice because it goes a little bit to what I believe is, one of the main problems that you have when going into compliance and with incorporating compliance procedures and systems, and is that there's a tendency to see compliance requirements as a kind of a checklist that takes time, and it's the people that constantly just say no to you, and you can do this, and how am I going to sell if you keep telling me not to do it? So and from the legal perspective, it's exactly the same thing. The clash between legal and the sales department in a retail industry, for example, it's incredible. So how do you confront that? That's a very good way to see it. You don't say no, you say yes, but.
Exactly. It's the messaging both ways, right? So the executive team has to give the compliance personnel autonomy and authority and sort of a seat at the table and make sure that they feel heard. And at the same time, the CCO has to look at the big picture and recognize that there's humans involved here, right? And how you message this and communicate this really matters because trust me, as a former attorney and now in compliance, I don't like saying no. Right? I want my clients to be happy with me and I want them to do the things that they want to accomplish. But really we're sort of those gatekeepers, right? We're the gatekeepers to protect everyone from themselves, right? And understand of hey, we want to grow the business, we want to take it this direction. How do we do it in a way that's going to protect us? And hopefully that will move the needle a little bit to building a strong culture.
Yes, yes, I completely agree. So Anna, thank you so much. It was a real pleasure. I think the time flew by, and I hope that people that are hearing us take a little bit of insight here, and there's something to be learned. And I really appreciate the time.
Absolutely. It was my pleasure. Thank you so much for the invitation. I've enjoyed our conversation.
You too. Thank you very much, and thank you everyone for listening to us. And we hope to hear you back, and that you will engage with us in future podcasts. But thank you very much, Anna, again.
All right. Thank you.
Bye, everyone.
Bye.